Hi everyone and welcome to week 10, second last week of new content, only one more week, and then for some of you, you're halfway through your diploma. So week 10, we're looking at the criminal courts and the judiciary, and we're going to introduce you to specialist courts. Now this isn't a really hugely long lecture, so I've done it all in one hit for you to just listen through. And for those of you who are doing police courts and criminal law with Greg, this is going to be a bit of revision, but I do need to go through it because we do have a few students that have not got to that course yet. So, first of all, the courts. What do they actually do? Think about what you see them doing on TV. On TV, people get arrested in 45 minutes and they get sent off to court and they're sentenced and it's all over. But who are the players in the courtroom? Well, there's the factual function of the courts, the finding of the facts from the evidence. The legal function, where they have to ascertain and apply the relevant laws of wherever the court is based. So for us in Queensland, that would be the Queensland laws. And the operative function, where they're ensuring that the courts operate effectively and efficiently. So the hierarchy of courts in Australia. Well, we'll start right down the bottom, where you've actually got the Magistrates Court. That is the lowest court in the land, and it is at the bottom, and they deal with the less serious matters. But having said that, they deal with the most matters. Hundreds of thousands of cases go through magistrates courts in this country every year. There is a federal magistrates court, but we'll just talk about the state one. So state magistrates court, people go in, most of them will plead guilty and they'll be sentenced by the magistrate. The magistrate will also hear committal hearings where the nature of the offence is much more serious, and the person will have to be committed to a higher court, which is either a district or a Supreme Court, where their case will be heard before a judge and a jury, usually a jury. Okay, Supreme Courts are the highest in each jurisdiction, and that is why we have the Supreme Courts of Queensland. It is in Brisbane. From the Supreme Court, you go to the High Court of Australia. Now, the High Court of Australia does not hear evidence. They are not deciding on guilt or innocence. They are deciding on matters of law. So they are simply going to make a decision as to whether the law was applied correctly to a case. They can change the constitution with the decisions that they make, less likely and very unusual. So the High Court of Australia was the one that recently heard the George Pell case and his appeal, that there were problems with the way that the case was run and the charges that were made, and ultimately he won that and he was let out of prison and will probably go on to live very quietly with some nuns or other priests somewhere. Gerard Baden-Clay's case went to the High Court as well. So it started off as a murder case. He was found guilty of that. On appeal, it was downgraded to manslaughter. And then the government appealed that to the High Court that it should have been murder. The High Court decided that, yes, it should have been murder, and that now stands and that can never be changed. So they were dealing on rules of law and how the case was conducted in the court, not whether he's guilty or innocent of everything. Then you've got your specialty courts like federal courts, family courts, things like that. So in Australia, we have what is called the adversarial system. So all of our laws and system came from England, and it is called the Westminster system. Now, back in the day, a long time ago, like centuries ago, when you offended in England, you offended against the king. He was always a king because before Queen Victoria, there were no queens. And the only reason that she got to be queen was because she had no brothers. Even after her, if there was a son, he got it over a daughter. So Queen Elizabeth, again, got it because there were no sons, although her line of the family wasn't supposed to get it at all because her father was the second brother. He only got it because his older brother abdicated, and there was only Elizabeth and her sister Margaret. That has now changed. So even though Charles is the next in line, he is the oldest in the family, even for him and his sister and brothers, even though Princess Anne is the next born after Charles, she would never ever become queen. It would pass from her to Andrew. So it was a male line of succession. That has now changed, and if anything happens to George and he falls over, it won't just automatically go down to Louis, it will go to Princess Charlotte. So if you committed an offence, you committed an offence against the king, and the king decided on the outcome. And of course, this has evolved over the last 1,000 years, and the laws have now all been codified into the criminal code. Okay, so common law is the foundation of our law, not only from the Westminster system, but also in the US. Canada is a Commonwealth country, so its system is based on the Westminster system as well. So it is an adversarial system. The state assigns criminal responsibility to an individual, and it is a contest between the state, which is the prosecution, and the accused, which is the defendant, the person who committed a crime now, or allegedly committed the crime. It is an adversarial system, but that doesn't mean that these people dislike each other and fight or anything like that. They're quite often very friendly, and they will quite often work together. If you do get to go and sit in court, you will see how this situation works. Students who in the past with police courts and criminal law, their piece of assessment was that they had to go and watch a court case, which you can't do at the moment. And that was one of the things that commonly came out in assessment, was the fact that they couldn't get over how friendly the prosecution and the defence actually were. So the core features here: prosecution and defence counsel determine the facts. They're tested in evidence by each counsel in an open court. Why is it important for us to have open courts? Well, for a start, it's due process, and it is seen to be afforded to the defendant. It can also cause a crisis of confidence in the community if they can't see that there is openness in what is happening in our courts. The only exception to open courts are when they are closed to the public to protect victims. So this is often seen in sexual abuse and domestic violence cases. So can you think of any countries, just while you're sitting there, that would have very closed courts? I'll give you a few seconds to think about that. So I'm hoping that some of the countries that you might think might have closed courts would be China, North Korea, Iran, and countries like that that are very secretive and controlling. So the judge or the magistrate in court is passive, and an unbiased referee who ensures compliance with the rules of evidence and due process is afforded to the defendant. If the defendant pleads guilty or is found guilty, the judge or magistrate proceeds to sentence the convicted defendant. So think about why the judge makes the sentencing and not the jury. Well, that is because the judge can use discretion in sentencing, and they can take mitigating and aggravating factors into account. Now, those of you who've done police courts and criminal law will understand exactly what mitigating and aggravating factors are. I think the rest of you can probably work out what they are. So the judge has the opportunity to take mitigating factors. So there might have been something that happened that caused the person to commit the crime that was beyond their control. Or aggravating factors might be the level of violence that they used or something like that. In the US, it's really quite different because the juries over there can do the sentencing, and the jury itself has the ability to sentence a person to death. I think that's really scary. I don't think that I would like to have that on my conscience. Okay, so the process, as we said, is adversarial. So whoever makes the allegation needs to prove that it actually happened. It needs to be proven beyond reasonable doubt. There needs to be a presumption of innocence made, and in this country we have the saying, innocent until proven guilty. So there is a presumption of even innocence. The defendant needs to have privilege against self-incrimination. They don't have to say anything if they don't want to. The judge is like the umpire who sits between the two sides and keeps them both in line. We have a rule of best evidence, so we must be presenting the best evidence. A stay of proceedings is where the court case may stop for a while and maybe someone needs to go away to get some more information or something like that, and then they come and resume the trial. It's a stay of proceedings. Victim impact statements. We'll do a bit more about this in week 11 when we'll talk about victimology, but victims often feel much better if they can be heard by doing a victim impact statement. Restorative justice conferences, where young people who may have committed a crime, which is just something really, really silly, they get the opportunity to face up to the person they committed the crime against and listen to how they have been impacted by this crime. Pre-trial case management, how the case is dealt with pre-trial and all the people that are involved with that, and early guilty pleas, which happens in most cases in this country that before they go to the Mags Court. Okay, so aims of sentencing, public confidence, truth in sentencing, mandatory penalties and sentencing disparities. There are a lot of issues around public confidence, around judges being too soft. So politicians will quite often say life should mean life. This is truth in sentencing, where if you are sentenced to life, it means life. Such as what Brendan Tarrant, the Christchurch shooter or terrorist, as he should be known, recently got in New Zealand. He has been jailed for life and he will die in jail. He'll never be let out. People in the public get really outraged around people being released early on parole, and this can all cause confidence falling in the judiciary. Okay, so there's a lot of issues out there with around how people are sentenced and what they are sentenced to. Mandatory penalties. This is related also to mandatory sentencing. So the newest ones that have just come in are mandatory penalties for assaulting emergency workers. And this is now all of them, not just police officers. The Queensland Police Union pushed really hard for this. So we get these mandatory sentencing and mandatory penalties that the judge doesn't have any discretion when it comes to aggravating or mitigating circumstances. It is mandated that that is the penalty. And sentencing parodies, well, this comes about a lot in the media because they'll compare two sentences of different people and they may not be exactly the same crime, but they'll whip up the public to get angry about different sentences being given. And even if it is the same crime and it's different sentences, there can be some very, very good reasons as to why they have been given different sentences. So sentencing guidelines, most sentences are not mandatory. So they have a maximum that the judge has the discretion to give up to, and some have minimum. So they get a range. So you might often hear that the sentence for an offence is 3 to 7 years, for instance. The judge has discretion within those two boundaries of how long he's going to give the sentence for. Some have minimum sentences, such as drink driving. So if you are 0.15 and above 3 times in a certain period, the mandated sentence there is just that you must receive a jail term. Okay, so there are concerns over judicial discretion that have resulted in strict guidelines, because think about some of the flaws with retribution where it is an eye for an eye and we're punishing for the crime, and there is no discretion there for mitigating and aggravating circumstances. So the judges don't always like mandatory sentencing, and quite often parliaments or politicians do it as a populist thing to gain votes and to be seen to be doing something about law and order. We have a state election coming up at the end of October. So we're going to hear a lot, I should imagine, about law and order in the next few weeks. I know that it's already started up in Townsville, where they have a huge youth crime problem. In fact, some kids stole a car and crashed it into the youth detention centre the other day. So they have a very big problem up there. Now this is called the sentencing table. US Federal Court would use this. We don't have any of this in Australia. We do not use this here, but you can look at it to get where your judgment should be. So if you are in Zone A and your offence level is on one of those numbers, This would all be given to the person who's doing it. And this is your criminal history points. You can see what sort of sentence you need to give. And have a look down here at the bottom of the table. Some of the table cuts off there for some reason, but some of them are some pretty severe sentencing, where, you know, up to 41 years here. So that must have been a very, very severe crime. Oh, it's months. Sorry. So anyway, what could be the problem with this being so rigid? What does it not take into account? Well, every case is different, so you can't just judge them all the same. So what if you had someone who's committed a Zone B level 9 offence, but it's their first offence and they're going to prison? At the very minimum, they're going to prison for 4 months. So, you have to think about, is sending this person to prison really the best thing to do? There may be many reasons why the person committed the crime and many good reasons to keep them out of prison, but it comes back to the idea of retribution, an eye for an eye, which is a very, very backwards looking principle of punishment. It's looking backwards because it's only punishing for the crime. It's not looking forwards about what can we do to make sure this person doesn't commit crime into the future. Magistrates do have a table here in Australia that they can use, but it's loose and it's not prescriptive as this one, and it will never happen here. Special considerations. So it can be that the case is really unique and these things have to be taken into account. And in Queensland, it is in the Penalties and Sentencing Act that they have to be taken into account. So offender remorse. If they are remorseful, they can get a reduced sentence. But how do you judge remorse? How many times do we see people that sound like they're only actually remorseful because they got caught? They're not actually remorseful. Well, the offender could write a letter, but it could be a fake. Some offenders will be more articulate than others and can sound really well and write really well and sound really genuine, whereas someone less literate may not write as well or be able to express themselves as well. But you can be sure that the first one is, but can you be sure that the first one is really remorseful? They may be genuinely remorseful. Accidents can happen. Imagine a bottle being thrown in a pub and hitting someone by accident and taking out an eye. They may realise, or they can realise, that they've got an anger management issue and they can be willing to get help. But it is a bad predictor of future offending. And we're going to discuss victimology. I think we discuss a little bit next week, either that or it's in 1010 next trimester. Civil law. So in Europe, they have a different system where the judges are not always neutral arbiters and there's no adversaries. Quite often the judges can be really involved in the court process. They can actually ask questions and take initiative, and they're not just confined to the issues put to them by legal counsel. So this becomes a slightly different way of doing things. We also had the thing in America with O.J. Simpson, where at his first criminal trial, or at the criminal trial, he was found innocent of murdering his ex-wife, but then when her family sued him for her wrongful death, he was found guilty. So that made it really, really quite interesting that he was innocent of killing her in a criminal court, but found responsible for her death in a civil court. Can a person go to jail from a civil trial? Well, the answer is usually no, they don't go to jail. It's usually a monetary settlement, and that's what happens in the O.J. Simpson case. I think her family were awarded something like $33 million. Okay, doctrine of precedent. This is a really, really important part of court cases. Have a think about it. Why can't a judge just go rogue and do their own thing? Why can't a judge say, I sentence you to a year on a tropical island with Tom Hanks and the coconut? They don't just do that. And why is this an important rule? Well, what the doctrine of precedence is where they find previous cases and use them in the current case to ensure consistency and fairness. And this can, of course, be affected if this type of crime's not been committed before, then there is no precedent to go back to. So in this case, that then becomes the precedent. And this would have been true with a lot of internet crimes that we've seen in the last 20 to 30 years. Every single one of those new internet crimes would be setting a precedent because it wouldn't have happened before. So how it works is that the judges in the lower courts are bound by the decisions of courts higher in the hierarchy, and this is referred to as the binding precedent. So when they are trying to make their judgment, they will look at cases that have happened before in the higher courts, and they will be bound by what precedent was set in that previous case. Okay, so normally courts at the same level should follow their own decisions unless convinced that the previous decision was clearly wrong. This applies to both statutes and common law. The only one that can't be overruled is the High Court, because it is the end of the line. Whatever the High Court decides, that is it. There is nowhere to appeal from there, and no other place to go for a higher up doctrine of precedent. The High Court sometimes also becomes the law of the land, as I did say back at the beginning, and they can make decisions on constitution as well. Statutes are those that are in the book, and common law are the procedures that we follow in our everyday life. Okay, how do we prove offences? So the prosecution has to take on board that the defendant has a presumption of innocence, and the burden and standard of proof is always on the prosecution. It is up to them to prove the elements of the crime and disprove any defences that are made out by the defence. The general rule with the defence is that they're actually not required to prove or disprove anything. It's not up to them to show that their client did not commit the crime. It is up to the prosecution to prove that they did. So therefore, the defendant has the right to silence. They don't have to say anything. And they have an evidential onus or a sufficient foundation or prima facie with their cases. So the exceptions here are rebutting presumptions around soundness of mind. And mental health and crime is something that we will talk about in Intro to Forensic Psych. We do a whole unit on mental health and crime. But when you're thinking about the prosecution and defence, have a think about which side do you think is likely to be more highly funded. Well, it's usually the prosecution, because they receive funding and are paid for by the government, because the prosecution is representing the government and bringing the case against the defendant. If you think sociologically about which class is more likely to be arrested, we're talking here about the lower class and people who are not earning a lot of money, if they are in fact working at all. And they're not going to be able to afford to hire expensive lawyers or barristers. So the prosecution often gets more money. So we move now on to the judge. What is the role of the judge? What do they do? Well, the judge is meant to be a neutral arbiter, the referee in the sport of court. They watch the whole game and they make sure the rules are followed. They intervene if they are not, they don't blow a whistle, and they bring it back on track. So they listen, decide, contemplate, and advise the jury without usurping their function. But who do judges talk to? Well, they talk to and listen to each other. They guide and advise each other. Some judges can be in charge of a bench trial, which means there is no jury, just them. There is a famous case in Brisbane, the murder of the Singh children, S-I-N-G-H, that happened, a good couple of decades ago now. And the fellow that did it made such a almost a spectacle of himself, but he pushed himself forward with the media quite a lot. And when he was finally arrested, after telling everyone that he was the main suspect for a very long time, when he was finally arrested, his defence was able to get him a bench trial, a judge-only trial, because they thought that there was not going to be a lot of people in Brisbane who would not have heard of this case and have formed an opinion. So you can have a bench trial with no jury. How many for a jury? Well, 12 in Queensland. And how serious does it have to be heard by a jury? Well, it has to be quite a serious crime. I'm just trying to think of the name of it right now, and it is just totally going away from me, but it's more serious for the Magistrates Court into the Supreme Court. Okay, and so as we know, the summary offences are those that are heard in the Magistrates Court, and the indictable offences are the ones that will go on to be heard in the higher court with a jury. So, contemporary judicial responsibility, contemporary as in the modern era, the umpire role inaccurate to describe contemporary times. So, the relaxation of the laws of evidence, the protection of witnesses and defendants, which is something that has changed a lot over the year. What are some options for providing evidence to stop trauma? Well, we now have video links. We now have closed courts to stop witnesses and victims from feeling as if they are extremely frightened, which is why a lot of people won't give evidence. Judicial responsibility, or judges can have greater fact-finding responsibilities in asking for evidence or clarification. So judges now assume greater responsibilities and don't simply apply to the rules. They have a wide range of discretion when it comes to sentencing. Think about how your lives would change if you went to prison. There are a lot of jobs that you all of a sudden wouldn't be able to do, and most of them are the ones that you've told me in your PowerPoint presentations that you want to do. They're gone. Exclusionary rules of evidence guidelines, not definitions. So a piece of evidence that has now been ruled out of use in trials is bite evidence. It went in the US, and it's now gone in Australia. So Ted Bundy was the last one that it was actually used for. It was used in the evidence of the murder of a little girl in Ipswich 40 to 50 years ago. Her name was Deidre Kennedy, and it was bite evidence that sent that fellow to prison. He since had that overruled and overturned and was able to get out again. And sometimes judges are able to stray out of their umpire's confines by actually questioning witnesses themselves, by doing a summing up themselves, by making alternative verdicts. So there are judges in the US that have changed the jury verdict, which leaves the case open for appeal. I don't know that that would happen here, but it would be interesting to see. So judges are becoming much more active in cases, and this happens a lot in specialty courts, which we're going to discuss in a second. Therapeutic jurisprudence. It's really important that you understand what this is. So jurisprudence is the study of the law. So what do you think therapeutic jurisprudence could mean? Well, it means using the law as a social tool actively. You can study the use of law as a social tool. So to put it in another frame, using drugs is illegal, but being an addict is not. So why don't we get the law to look at why people become addicts and treat that? And that can be done in the drug courts. It can follow a pattern for these people. You know, you've got kids that will be smoking weed when they're 13. They've moved on to harder drugs at 16. Then they get onto ice and then they get arrested. So remember that we discussed early on that the police are the gatekeepers, and they've got the discretion to make decisions about what happens now. If that young person has never been arrested, the law can now be used as a therapeutic tool to divert the person away from court. So this is where they can start to use diversionary conferences, treatment programs, and people can end up going through these sorts of programs without having a criminal record at the end. It's also used a great deal in veterans courts in the US, which we don't have here, and we don't need to have here. We have so few veterans in them and so few veterans in trouble, and we have so many more programs here in place to help them. But people who go to therapeutic courts are more satisfied with the process. So specialty courts, often called or also called problem-oriented courts. This is where the specific problems or offenders go to a court that is specific for their issue. So there are lots of them, but they only deal with one matter. They have limited jurisdiction and are presided over by a judicial officer with expertise in that area. So for instance, with the veterans courts in America, the judge and quite often the lawyers and all of the court staff can be veterans themselves. So they all have expertise and knowledge of what it is like for these veterans. So the problem-oriented court is different. It seeks to use the authority of the court to address the underlying problems. So every one of them came into existence in response to a particular problem that may have been getting quite big and quite out of hand. So it's really difficult to make generalisations about all specialty courts. But here's a few of them. Domestic and family violence courts. We only have one in Queensland and it's at Southport on the Gold Coast. We have drug and alcohol courts. We have Murray courts, which are the Aboriginal and Torres Strait Islander courts. We have mental impairment courts or the mental health courts. We have court intervention programs. Then we also have, that aren't listed here, but there's the Children's Court, the Coroner's Court, the Land Court, the Planning and Environment Court. And each of these courts specifically only deals with that particular problem that comes before them. So these courts give judges more options. So take the Murray Court, for example. What does it look like? Well, in the Murray Court, there are elders in place of or working with the judge so that they make decisions that are relevant and appropriate to Aboriginal and Torres Strait Islander people. Drug courts, they take into account who is getting arrested. Think about an addict's life. What do you think it would look like? Their main priority is to get drugs, right? So if they have children, the kids are going to come second. Their living conditions are likely to be poor, probably squalid, as will their physical condition, because their money will all go in drugs. If they are arrested and fined, they will go straight back to it and it becomes a cycle. So their addiction is not a legal problem, as addiction is not a crime. So can they be treated the same as a person arrested for violence? And this is where these specific courts come into their own. The court can use the power of the law to help people with their underlying issues and problems, so they don't just let them go, but get them to do things to address the problem. And there are much better outcomes in specialty courts to normal courts. And we will watch an absolutely excellent video about a drug court in America from the point of view of the judge who runs it, who is someone that Mayessa knows, and it's really fantastic. It's a TED Talk, but it's really fantastic, and we'll watch that in tutorial. Okay, so the most recent incarnation of specialist courts here in Queensland is the DV Court, which is focused on providing treatment to offenders while protecting their victims. Okay, but trying to deal with the problem behind the domestic violence, not just the domestic violence. There's a couple of videos there. They are both American and they do talk about domestic violence courts. And the second one that says start at 1 minute started at the beginning, because before 1 minute, the lady starts talking and giving some background. But they are excellent examples of how domestic violence courts can support the victims as well as supporting the offenders while not condoning what they're doing. Okay, that's it for this lecture. I told you it was going to be a little bit shorter, thank goodness. I will see you in class on Friday. Have a great week, y'all. Shouldn't do that, should I? I'm not American.